Good afternoon and welcome. Thank you all for finding time to attend our seventh IPA Power Hour webinar on carbon mitigation credits and CEJA's support for at-risk nuclear plants. My name is Megha Hamal and I am the Communications Manager at the Illinois Power Agency. To get started, let's go over a few housekeeping items. Today's session is being recorded. A recorded version of this session will be available on the IPA website under About IPA and then Events tab, along with the PDF of the presentation sometime this afternoon. To reduce any background noise, all participants are muted upon entry. Please feel free to ask questions at any time during the webinar. We will reserve some time towards the end of the presentation to address these questions. To submit questions, please use the chat feature at the bottom of the Zoom window. We have also enabled live transcript for the meeting today. If you wish to hide the live transcript, you may simply click on the live transcript button, then click Hide Subtitle. Today, we will start the presentation by giving you a brief background on the Zero Emission Standard Plan, including process and procurement around it. The Future Energy Jobs Act, or Public Act 99-0906, which took effect in 2017, directed the IPA to develop a Zero Emission Standard Procurement Plan and hold a procurement for zero emission credits. This background will provide participants a good reference point to understand the role of the Carbon Mitigation Credit Procurement Plan that defines the process for the IPA to conduct a carbon mitigation procurement event per CEJA to procure carbon mitigation credits from nuclear plants that do not emit carbon dioxide. In this presentation, we will also give you a quick insight into broader CEJA negotiations, including nuclear negotiations leading up to the bill passage on September 15th, 2021. Our presenters for this session are Anthony Starr, Director, Illinois Power Agency, Brian Granahan, Chief Legal Counsel, Illinois Power Agency. After the presentation, our presenters will take questions from participants. Finally, after the Q&A, IPA Director Anthony Starr will wrap up this year's Power Hour webinar series with closing remarks. Now, I would like to give you an overview on the IPA Power Hour webinar series and its scope. Power Hour is a newly launched series of educational and informative presentation on a wide range of clean energy topics and emerging issues. We will provide a brief background on the Zero Emission Standard Plan today, like I mentioned, information on carbon mitigation credits, a comparison of carbon mitigation credits with zero emission credits and renewable energy credits. We'll also talk about CEJA negotiation leading up to the bill passage on September 15, 2021. Past IPA Power Hour webinars have covered other topical areas impacted by CEJA. What we will not cover are items from CEJA that are related to stakeholder feedback process, related to the adjustable block program opening and the revised long-term plan development. We will also not cover specific program or procurement requirements or issues outside the purview of the IPA, such as changes to rate making, electric vehicle and transportation incentives, programs administered by other state agencies. This leads me to my next slide, which gives you a snapshot of the Power Hour webinars we've completed to date. We've already completed 6, and today is the 7th Power Hour, which also happens to be the last Power Hour webinar for 2021. We will continue with our Power Hour webinars. Future Power Hour webinars will be held in 2022, and details are forthcoming on that, so stay tuned. The recordings of Power Hour and registration links where you can in the future, you can register for Power Hour webinars in that link that we have presented on the slide. So here's a quick overview on the Illinois Power Agency. So the Illinois Power Agency is an independent state agency established under Illinois law in 2007. it is charged with the development and implementation of energy procurement plans for residential and small commercial customers of Illinois electric utilities. The IPA is also responsible for the development and implementation of other procurement plans, including those that support new renewable energy development and the continued operation of nuclear plants. The IPA administers incentive programs and conducts energy procurements to promote renewable and zero carbon and energy generation to benefit all Illinoisans. So that concludes my portion of the presentation. With that, I am going to hand over the presentation to IPA Director Anthony Starr. Anthony?
Great, thank you, Megha. So to begin, what I'm going to do this afternoon is set the stage for why we have a zero emission standard and subsequently a carbon mitigation credit procurement, and provide a little background about the nuclear power industry in Illinois and the challenges that it faced that led to the policy decisions adopted by the General Assembly to support at-risk nuclear plants. Next slide, please. So in terms of a background on nuclear power in Illinois, I think the thing that is really significant about Illinois is that we're the state that is the most nuclear heavy state in the country. We have at the moment 6 operating plants with 11 reactors. 5 of those are in the PJM region of the state, the northern part of Illinois, where ComEd is, and one of those plants is in the MISO portion of the state. There was previously also reactors at Zion and a few other reactors that have at some of the existing sites that have closed down as well. We'll get into this in a little bit more detail in a later slide. Basically, the nuclear fleet in Illinois is all owned by Exelon. Nuclear power is also a very significant portion of the Illinois generating mix. Over 90 million megawatt hours of generation a year comes from nuclear power in Illinois. By way of contrast, Illinois is an energy exporting state, but the consumption of electricity in Illinois is roughly 120 million megawatt hours a year. So as you can see, the obviously electricity markets are multi-state markets, and energy flows back and forth all the time. But in terms of the scale of nuclear power in Illinois versus the use of electricity in Illinois, it's a very significant portion of the power that keeps our lights on and our businesses and homes operating. And it is carbon-free generation. Nuclear power plants do not emit any carbon. Thousands of jobs are also associated with these plants, and in the regions where the plants are, and we'll have a map on a later slide, these are good, stable, heavily unionized jobs, well-paying jobs that really help the plants in Illinois, the communities they're located in, really are sort of economic development engines for those communities in terms of the operations of those plants, but then they also are part of the important part of the generation mix in Illinois. These plants also provide significant local tax revenue. A lot of the challenge that is faced by nuclear power in Illinois comes from the fact that Illinois is a restructured state. We're one of the roughly half the states in the country that chose to restructure its electric industry. A real wave of this sort of started in the late 90s, came kind of crashing to a halt with things that went wrong in California. But overall, in the United States, we really have 2 sort of ways in which we structure our electric industry. We have states that are traditionally structured where you have what are known as vertically integrated utilities, where one utility owns the power plants, owns the wires, all the way down to people's homes. And then you have states like Illinois and many of the East Coast states that have a restructured industry where we've separated out ownership and control over different parts of the electric grid, the transmission grid, and generation. And in particular, generators are what are known as operating on a merchant basis, meaning that they work in markets where they buy and sell their commodity, and their economic viability is based upon the participation in those markets. This is different from a traditionally regulated state where the whole suite of things that the electric utility has, from its power plants down through the poles and wires in the going down streets and alleys, are all part of what is known as the rate base of the utility. And the way in which the ebb and flow of electricity markets and consumption and prices is handled is through a traditional rate case structure, where if the revenues being collected are not sufficient, there is a process by which the utility can go before the regulatory commission in a rate case and have rates adjusted to ensure that they are meeting their regulated rate of return. That opportunity does not exist in a restructured state for power plants, where those power plants do not have a guaranteed rate of return like a traditionally regulated utility would have. And as a result of that restructuring, that's one of the things that helped create competition in the market, helped lower electricity prices in Illinois, which is a great benefit to customers. But as energy revenues declined through the 2010s, this increasingly became a challenge for the nuclear power industry in Illinois. Next slide, please. This is a little bit more in terms of how Illinois really looks different from any other state in the country, in that the overall share of electricity generated in Illinois, as you can see, is we generate the most electricity from nuclear power of any state, but also one of the highest percentages. This slide is data from 2019. Since this data came out, some of these numbers presumably would have changed. There's been retirements in both Pennsylvania and New York, so you would see declining shares of nuclear power there. South Carolina, the Vogtle plants are still under construction, are supposed to be coming online in the next couple of years. So you might see the South Carolina share increase. So they may be the one other state that rivals Illinois in terms of its focus on nuclear power as part of its generation mix. And a really significant thing to keep in mind here too is that as we think about bigger climate goals, as we're working on the expansion of other clean energy parts of the Illinois electric system, this is sort of real bedrock, starting out with half of our power being generated from a carbon-free resource is an important starting point that would be different from if we had a different generation mix like many of the states around us have that are more fossil fuel dependent. Next slide, please. So this is a quick overview of the power of nuclear power plants in Illinois. It does not include the Zion facility, which I'm forgetting what date, when I think it was late 90s that it retired. I'm forget, it's been a while. So that's no longer an operating facility, but we have 6 sites right now with operating nuclear power plants. 5 of those have 2 reactors. The Clinton station is the one plant in Illinois which only has 1 reactor. 5 of the 6 plants are fully owned by Exelon. The Quad Cities plant is 75% owned by Exelon and 25% owned by Mid-American. And as you can see, some of the, our oldest operating reactor in Illinois started operation in 1969. And then there was obviously a large construction boom in the nuclear industry in Illinois, with a lot of plants coming online in the mid to late 80s. And they have various license expirations stretching out from later this decade well into the 2040s. There are various processes by which some of those licenses can be extended. That's the questions of longer term viability of the nuclear industry is a bigger picture issue, but the real immediate issue and concern is, what do we do through the balance of this decade to make sure that these power plants are part of the generation mix and generation options available in Illinois. Next slide, please. So just a quick map, if you're not familiar, this is the location of the nuclear power plants in Illinois, mostly in the northern portion of the state, Clinton being the one plant further south in Illinois. Next slide. So a little bit of a background on how we got to the Future Energy Jobs Act, which was the first time that the Illinois Power Agency got involved with how to support at-risk nuclear plants. And Brian will shortly be going into the details of that as a way of sort of setting the stage for the provisions around nuclear that were contained in CEJA. This really started in earnest with House Resolution 1146, which was adopted in the spring of 2014 and directed a number of state agencies to look at what would happen if a set of at-risk nuclear power plants closed. So the Illinois Power Agency was asked to look at reliability and capacity issues for the Midwest region. The Department of Commerce and Economic Opportunity, the Illinois Environmental Protection Agency, and the Illinois Commerce Commission also were given specific roles to look at specific issues around the impact of nuclear power plants closing. So those ranged from the economic impacts, impacts on prices, impacts on the environment because of a change in emissions profile. So those reports were each done by the agencies over the course of 2014 and led to a report being released in January of 2015. The resolution specifically had us look at the subset of plants of Quad Cities, Clinton, and Byron, and available as a link for that report. And the outcome of that report was it provided a bunch of potential policy options, and that really became the source of a variety of legislative proposals across 2015 and 2016. So recognizing, okay, there's an issue here that needs to be addressed, and there's a variety of ways in which support for at-risk nuclear plants could be provided, and what is the best way to have that be done, and there are a variety of legislative proposals that Brian will be discussing, and ultimately coalesced in the Future Energy Jobs Act that passed at the end of 2016. As many of you know, this is where the issues around the renewable portfolio standard were initially addressed in terms of consolidating the ARIES compliance and the incumbent utility compliance into a single RPS. It created the programs that the Illinois Power Agency currently runs, the Adjustable Block Program and the Illinois Solar for All program. It expanded and revised energy efficiency requirements, a number of other aspects as well. But then also a key component of that was the support for at-risk nuclear plants through the development of the Zero Emission Standard. And with that, I will turn it to Brian, who will go into more detail on the Zero Emission Standard process and its procurement.
Thank you, Anthony. So as this is Brian Granahan, I'm the Chief Legal Counsel at the Illinois Power Agency, and what we'll be discussing is what the outcome was from the Future Energy Jobs Act for supporting at-risk nuclear plants in Illinois. That is ultimately manifested in what's called the Zero Emission Standard, found in Section 1-75 D-5 of the Illinois Power Agency Act. So as we go to the next slide. So, and I apologize for this because I'm missing an H from how, but under the Zero Emission Standard, how is state administered support provided to nuclear plants at risk of closure? In other words, we have these analyses that say, hey, here's what would happen if nuclear plants go offline. There's an initiative on behalf of the state discussed in the legislature to try to keep these nuclear plants online. How does that ultimately happen through state law? Well, it's not dissimilar to what's done to support new renewable energy development in terms of keeping these existing plants online. Specifically, zero emission credits, or ZECs, are procured by Illinois utilities. And by virtue of procuring those ZECs, there's a payment that's made back to the plant operator who produces those ZECs. And that provides revenue back to plants, get some additional revenue certainty to make up for potential shortfalls from declining energy prices or other places where maybe their costs are increasing or the revenues are decreasing, and gives them essentially financial support to keep those at-risk nuclear plants online. That then provides environmental benefits back to the state by virtue of keeping this carbon-free energy online, and the zero emission credits are retired by the Illinois electric utilities and used to meet a compliance requirement in Illinois law. As mentioned, these requirements are found in Section 1-75D-5 of the IPA Act. The definitions of a zero emission facility, which we'll talk about in some later slides as well, and zero emission credits are found in the definition section of the IPA Act. ZECs are very similar to renewable energy credits insofar as they constitute 1 megawatt hour of generation from a qualifying facility. Here, that qualifying facility is a nuclear power facility. With respect to RECs, that qualifying facility is a renewable energy generating facility. Now, they aren't traded in liquid markets in quite the same way that we're aware of. By and large, this is a state-created property right that is pretty much just transferred pursuant to these requirements of state law, whereas you see renewable energy credits traded in liquid markets and used by, say, corporate clients to be retired to meet sustainability goals. Not really aware of that happening with zero emission credits, but the platforms used for their trading and retirement are the same, which are GATS and MREDs. So we have a slide coming up when we get into carbon mitigation credits to talk about the differences and similarities between carbon mitigation credits, zero emission credits, and renewable energy credits. So going on to the next slide and some of the mechanics around the zero emission standard. So what exactly does it require the state to do? Well, specifically, it requires the procurement of zero emission credits constituting 16% of a contracting utility's load. And the contracted utilities here, as shown at the bottom line, are ComEd, Ameren Illinois, and Mid-American Energy Company. What this basically means is 16% comes out to about 20 million megawatt hours, or 20 million ZECs procured annually. So that's the procurement target for the procurement of zero emission credits found in the law. Projects, in order to qualify to be able to sell their zero emission credits, must be nuclear plants in PJM or MISO. It didn't necessarily have to be the plants that were discussed in the HR 1146 reports and negotiations. And this is something that I think is oftentimes of interest to parties who are curious about how we apply this. But instead, what's referred to the law is not those plants by name or those specific sites, but instead there's a discussion of public interest criteria that would be applied for the selection of facilities that ultimately apply to the procurement. So then we basically take that public interest criteria, turn that into a scoring system, also add in a multiplier based on that facility's risk of closure, based on financial information that it submits, and score any applicant bids. Now, facilities that provide those sorts of public interest criteria standards, whether it's environmental benefits or public health benefits or whatever it might be, back to Illinois residents, they're probably going to score better if they're located in Illinois, but it doesn't mean that facilities from out of state would have been excluded from participating. The contract length for the procurement of zero emission credits is 10 years. And again, the counterparties are the three of ComEd, Ameren Illinois, Mid-American Energy Company. All three of those have zero emission credit procurement contracts. So on to the next slide. So one interesting aspect of how the zero emission standard is structured is how zero emission credit prices are calculated. This is all taken from statute. It's prescriptive in statute, although they're all floating aspects of it based on market information. But you begin with the social cost of carbon, which is reduced down to $16.50 per megawatt hour. And then eventually, beginning in 2023, over the course of these 10-year contracts, that will increase by 1 megawatt hour per year. That social cost of carbon outside of the escalator cannot be adjusted upward, but it can be adjusted downward. And the way it can be adjusted downward is if potential revenues available to those nuclear plants go up. For instance, if energy and capacity prices are particularly high, and as a consequence, they're in a better condition financially than maybe was anticipated previously, then the ZEC price can be adjusted downward. We've included here a link for how we calculate that ZEC price on an annual basis. You can see the calculation. Basically, you would need a market price index that exceeded the baseline market price index of $31.40. And if it did, if that was representative of the revenues that may be available to one of these facilities, then there would be a downward adjustment in the zero emission credit price. At the same time, there's also an annual cost cap, very similar to what's found in the state's RPS, especially the state's RPS under the Future Energy Jobs Act. It's 1.65% of 2009 rates, and then you multiply that times the prior year's number of kilowatt hours delivered, and it gives you an annual cost cap. If you go back to our RPS power hours, we talked about how that cost cap under the Future Energy Jobs Act was about $230 million, and then now it's going up to well over $500 million. Here for the zero emission standard is $235 million. That's the annual amount that could be spent on zero emission credits. That is basically the rate impact cap on ratepayers. At the same time, if you take that 1650 times the 20 million ZEC quantity, you would actually end up with a number around 330 million. And what ends up being happen is that if you can't pay for all of those ZECs in a given year, then that gets rolled over the next year as part of unpaid contractual volume to be paid in future years, but never above that total annual rate impact cap. So the law does envision that there's the possibility that you'll have more ZECs being procured than you'll have money to pay for. But in another year, if prices happen to sink quite a bit lower, you would have that backlog that would be paid in that future year. So those are the mechanics associated with the zero emission credit price setting. As we go to the next slide. So how is all of this ultimately settled out? And this is, again, a familiar process if you're familiar with other things that the IPA does, and that we wrap everything up in one of these procurement plans. We publish that for comments, and then we file it with the Illinois Commerce Commission for its approval, and parties can offer arguments in that litigation. And then once that Illinois Commerce Commission approval is achieved, move forward with the procurement event. Here, all of this was done under the zero emission standard across, I believe it was June, July, August, and September of 2017. The Future Energy Jobs Act was signed into law on December 7th, 2016. but did not take effect until June 1st, 2017. And we had under law from that point in time 45 days to publish the initial draft of our Zero Emission Standard Procurement Plan. What was in that plan? Well, one of the major issues that we had to figure out through that plan was exactly how we take this quoted text regarding public interest criteria that is a proxy for benefits to Illinois residents and reduce that down into a quantitative scoring system in case we had bids from nuclear facilities that maybe weren't contemplated during negotiations, but had every right to participate under state law. And so that was one of the big things that we did through the Zero Emission Standard Procurement Plan, was try to figure out a scoring system using these qualitative factors to score potentially competing bids. And then a lot of what we did there actually informed what was done on renewables for adjacent state projects in our long-term renewable resource procurement plan that we will be developing in the months thereafter. So that gave us a good run at trying to figure out, okay, how do you take these environmental factors and then judge whether a plant is making a more positive contribution than another plant? And that's all wrapped up in our Zero Emission Standard Plan. There's also aspects of this about assessing whether these facilities would not exist but for the existence of that Zero Emission Credit Delivery contract, i.e., what is the financial risk being faced by that facility? So we ended up with a risk multiplier, a risk of closure multiplier that was also used in the bid evaluation process. So moving on to the next slide. So the procurement process itself, we went through the development of our Zero Emission Standard Procurement Plan across June and July of 2017. Plan was approved in September of 2017. The procurement event, all the development materials, the Zero Emission Credit Delivery contracts, the procurement requirements, different forms. All of this is one of those things where the more you get into it, the more complex and layered it is than just sort of a two-step process. Registration of bidders, the submission of information, all of that occurred across the fall and winter of 2017. And the selected facilities were Quad Cities 1 and 2 in Clinton. So they deliver approximately 20 million zero emission credits annually now to Illinois electric utilities and are paid for those zero emission credits. And by virtue of receiving that revenue, they have a commitment also to stay online over the course of the zero emission credit contract. That's something that's found in state law. So you have these at-risk nuclear facilities. They're receiving support through the presence of a zero emission credit delivery contract in accordance with the terms that we discussed in prior slides. That keeps those plants up and running. It allows the state to preserve the environmental benefits of those facilities that were adjudged to be the strongest. And that's where things were left after 2017 with respect to 2 of the 6 nuclear plants in Illinois. And that's pretty much just an overview of the zero emission standard, the zero emission credit procurement process, and it helps set the stage from some discussion of what came next through the procurement of carbon mitigation credits. Before that, though, one more slide about the legal challenge of the zero emission standard, because I feel like it's important to at least conclude that as well. So zoom to the next slide. So much to Anthony's chagrin, the IPA directors and named defendants in a federal lawsuit brought challenging the constitutionality of the zero emission standard, not because of anything that the IPA did. This was actually a suit that was filed on February 14th of 2017. So it was basically challenging, it was a facial challenge to the constitutionality of the law, but because we and the ICC were implementing agencies, the directors in their official capacities ended up being named defendants. So the suits were brought in U.S. District Court in Northern District of Illinois. They had 2 primary constitutional challenges. One was a dormant Commerce Clause argument, essentially saying, well, you're saying that these are the facilities that actually have to be selected under this procurement process, and these facilities are in state. You're not allowing for out-of-state participation. Never felt like that was a very compelling argument, given the way that the law was written and all the public interest criteria that goes to facility selection, and the fact that the definitions of the facilities can include plants across PJM and MISO. The second set of arguments, which comes up pretty commonly in this area, were preemption or supremacy clause arguments, where the argument goes somewhere along the lines of, well, look, the federal government under the Federal Power Act has regulatory authority over wholesale energy markets. And if the state is providing financial support to certain plants, then it's potentially depressing the price that's being bid into those wholesale energy markets in a way that's disruptive to the federal government's ability to regulate those markets. And so the state is effectively entering into the domain of something that's left to the federal government to regulate. Now, the argument the other way goes that environmental benefits and public health benefits are within the traditional police power of states. Market effects may be incidental. A lot of it comes down to why things were done and how they were structured. Ultimately, there was a parallel New York case, I think, filed before the Illinois case was filed, but ultimately resolved after the Illinois case was resolved, or at least the Court of Appeals opinion came later. All of this ended up being dismissed by the district court, and then appeal on the Epsom Star case was denied by the Seventh Circuit, and cert was denied by the U.S. Supreme Court. So all of that was settled out. I did want to include a link to the State Power Project because they do a great job of summarizing these sorts of issues that go on, where you have states on the one hand trying to promote clean energy and make sure that public health benefits, environmental benefits, resource diversity benefits, grid resilience benefits are being captured for Illinois residents. And then on the other hand, you have the federal government who's trying to ensure competitive wholesale markets, and the tug of war that goes back and forth, whether within respective legislatures or within courts, is all captured very well on the State Power Project website. And you can see just a litany of cases that have come up along those lines there. So now we move into the development of the Climate and Equitable Jobs Act over the years that followed the enactment of the Zero Emission Standard. So I think a lot of parties are familiar or a lot of our participants are familiar with from our prior power hours with the Climate and Equitable Jobs Act, but we haven't had much time to talk about the nuclear piece of it. So that's what we'll be able to talk about today. Let's move on to the next slide. So what was going on here? What was being negotiated over with the Climate and Equitable Jobs Act? Well, there were some big picture items that certainly came up, and you saw this in a variety of legislative proposals we'll describe in later slides. There was a strong need for utility ethics and rate-making reform. There were certain parties who felt like formula rates was something they wanted to move on from, and obviously there were some issues that were described publicly about utilities, and this all came to a head in different bills. There was a recognized need for continuing to support at-risk nuclear plants, ultimately, especially as we were moving toward more aggressive clean energy goals. Keeping these baseline facilities and their carbon-free energy online became a real point of emphasis. As we talked about in prior power hours, RPS funding had effectively run out, and there were challenges facing the solar industry and its ability to develop new projects without state support. A huge emphasis on equity and labor standards, and then a multitude of additional issues. And I apologize for any that have been left out, but there were so many issues wrapped up in a 900+ page bill that I just wanted to give a brief overview on it. With respect to nuclear specific items, you had the same sort of phenomenon that I think Anthony described in the earlier slides, where you have these nuclear plants that compete in competitive markets, and they might have, if not more fixed cost structures that they don't have as much control over, whether it's fuel costs or operation and maintenance costs. At the same time, you're seeing energy revenues decline over time, and for reasons that are good for Illinois ratepayers. They're paying less in electricity costs, but at the same time, these plants are receiving less energy receiving less energy revenue, and ultimately may be at risk of closure. And then there's questions about, well, then how do we support those plants? And there were risks associated at the time of those plants receiving capacity revenues, if supported by the state, potentially being placed at risk by rules that were being considered by PJM. So if they participated in a capacity market and were receiving state-administered funding to help support their efforts to stay online, then PJM was considering requirements that said, well, then you are subject to a minimum offer price rule, and your minimum price would be a certain amount. And if the market cleared below your minimum offer, then ultimately you would be shut out from participating and receiving those revenues as well. And that informed a lot of parties' legislative proposals that we saw across especially 2019 and 2020. At one point, the governor's office and the Illinois Environmental Protection Agency wanted to have their own third-party consultant reports around what plants are at risk of closure, what levels of financial support may be necessary, what do future energy revenues ultimately look like, how can we model this out and make sure that we're offering a more refined alternative back in terms of providing support to nuclear plants. Another big aspect of this is just that those future revenues are really unpredictable. How do we make adjustments in any model to provide financial support for higher or lower revenues than were expected, or for that matter, if there's a lot of federal support coming, which is something that's being contemplated now in the Build Back Better Act, or if you have, in the case of the minimum offer price rule, a plant that can no longer receive capacity revenues because it's shut out from participating in that market. So then once we landed on a model that looks like the carbon mitigation contracts, all right, for how long? The zero emission credit contracts were 10 years in length, began 5 years earlier than these contracts. How long should these contracts be? So all of these things were being kicked around. There were different proposals available in bills, different ideas being shared. And all of this, certainly, if parties were interested, they could view some of that through some of the different legislative hearings that were held at that time. And as we move on to the next slide, this is just a rundown. It's something that we took from a prior Power Hour slide of all the different bills that were proposed across 2019 and 2021. There's additional proposals even beyond these, but just to give you some sense, each party kind of had its own set of ideas or its own problems that it wanted to solve, introduce legislation to that effect, whether you're solar developers, whether you're owners of coal plants and want to develop solar there, whether you're labor interests, whether you're the Clean Jobs Coalition and your interests around equity and clean energy development. So you saw all these different proposals ultimately coming through, many of which contained different variations on themes for how to support at-risk nuclear plants to make sure those facilities stayed online. So as we go to the next slide. So the process here for the Climate and Equitable Jobs Act ultimately becoming a part of state law, ultimately becoming Public Act 102-0662, about a 2.5-year process from many of those bills being introduced, the concepts being discussed, to the actual conclusion of a bill being signed into law. So much happened during that period, including a global health pandemic that ultimately threw things for a loop. Things really started to build to a pressure point, especially across August and September of 2021, because Exelon was saying, look, we haven't gotten to any resolution around support for at-risk nuclear plants. And until we do so, we have to move forward with potentially shutting down some of these plants because we don't think they're profitable in the long term. And that, along with continued RPS issues where we didn't have funding for additional solar projects with the RPS, you saw this pressure build up. And eventually we reached a point where in early September, we were able to achieve successful votes from the House and the Senate and a signature from the governor's office. And now we have Public Act 102-0662 in place that does provide support for at-risk nuclear plants through the procurement of carbon mitigation credits. Let's go to the next slide. So the Climate and Equitable Jobs Act, signed into law on September 15th, 2021, does a number of things, as we've talked about some of the prior Power Hours, or maybe fall out of things that the IPA is tasked with administering. But one of the main ones that provides support for at-risk nuclear plants through the procurement of carbon mitigation credits, similar to what we were talking about before with zero emission credits, but different in ways that we'll get into in future slides. But again, the idea is the state's electric utilities, in this case, actually for carbon mitigation credits, only ComEd, they're procuring the environmental attributes of these facilities. Revenue is going back to those facilities from the 1A ratepayers. Those facilities are able to stay online, and then we all benefit from the socialized benefits associated with having this clean energy remain online for a longer period of time, whether it's meeting our emissions goals, whether it's reliability concerns, pricing concerns. Those benefits are then captured through keeping the facilities online through the support provided under the Carbon Mitigation Credit Procurement Plan. That plan was required to be published in 7 days of the effective date of the act. We actually published it 2 days later, and you might wonder, well, how can you do that? This is a fairly complex plan. The truth is that most of the negotiation around the nuclear piece seemed to be wrapped up by late May or so. And then there were some changes over the summer and things that we saw, but most of it was in the margins. So what we tried to do is write what we could over the summer, recognizing that ultimately when the bill passed, it's the sort of thing that we'd want to at least have ready. So as we saw different iterations of bills come out and say, okay, this seems fixed across these different iterations of legislation, let's go ahead and prepare for it while we can so that we can move forward with this quickly, especially given all of the work that we have to do on renewables and in other areas in the months that follow. So the Carbon Mitigation Credit Procurement Plan was published on September 17, 2021, put out for public comment, and then ultimately filed with the ICC on September 29th of 2021. So as we go to the next slide. So just a quick rundown of a comparison between carbon mitigation credits, zero emission credits, and RECs. So we talk about these things all, of course, end in C as they're all credits, and they all represent the environmental attributes of 1 megawatt of electricity of each of the generating facilities that qualify to produce those credits. So they're decoupled from the energy or capacity, and the credits themselves can be traded and sold separately. And if you purchase and retire those credits, then you can claim the environmental benefits associated with that generation. So when you see something that might be, for instance, you see a label on a product and it says that it was produced by renewable power, it may not be necessarily the case that the actual underlying energy was produced by a wind farm or a solar plant that ultimately fueled the mechanical processes that produced that product, but instead it might have been the purchase of renewable energy credits that ultimately gave rise to the ability to make the claim that renewable energy was used in that transaction. The same thing holds true for zero emission credits, carbon mitigation credits. They allow you to claim the environmental benefits by virtue of purchasing and retiring those credits. The generating facility requirements for renewables and for renewable energy credits, it's all contained in the IPA Act. And oftentimes, and previously in Illinois, right now in Illinois, the RPS pretty much just focuses on new wind development and new solar development. But in many jurisdictions, and in Illinois, probably before the Future Energy Jobs Act, there was a lot of controversy around whether certain technologies would qualify, whether it's landfill gas, or does that constitute renewables? And that ends up being a bit of a flashpoint for concern. Nuclear power is not listed, so nuclear power plants cannot produce RECs, but renewable facilities cannot produce ZECs or carbon mitigation credits. And ZECs and carbon mitigation credits are effectively the same, but carbon mitigation credits have to come from plants that are located in PJM, according to section 1-75D10 of the IPA Act. But for all intents and purposes, they're similar in terms of their generation. They're just different in terms of the terms by state law on which they're purchased. So as we go to the next slide. Just a bit more here. In each case, the RPS requires the retirement of RECs by utilities. The same thing is true of the Zero Emission Standard and Carbon Mitigation Credit Procurement process. So those ZECs and carbon mitigation credits cannot be resold by the utilities after procurement. They have to be retired, and thus the environmental benefits can be taken. They can all be traded over GATS and MRETs. So effectively, you have these platforms that exist as trading platforms and generation platforms for these environmental credits, and the same classic platforms that are used for RECs ultimately are used for ZECs and carbon mitigation credits as well. As I talked about a little bit previously, you do see RECs traded in liquid markets. That's not uncommon. There are firms that ultimately exist to try to pool those together, whether it's a retail supplier's use or a big corporate client's use. Not aware of the same thing happening with zero emission credits or carbon mitigation credits. It's not in Illinois. If that's happening with nuclear plants writ large, maybe it's the sort of thing that we wouldn't have visibility into at the IPA. Facility locational requirements for RECs, there aren't actually locational requirements in Illinois law for RECs, but for RECs that are procured for the Illinois RPS, there are, and those are found in section 1-75C1I of the IPA Act, and then written up in, I believe it's chapter 4 of our long-term plan. And that allows for certain facilities in adjacent states to produce RECs that can qualify for the Illinois RPS. But for those that are traded separate from the Illinois RPS compliance, you don't have those same locational requirements apply. Those are found within the Illinois RPS. For ZECs, the facility has to be located in PJM or MISO, and then for carbon mitigation credits, it must be located in PJM. So hopefully that's a useful primer as we get into some of the particulars associated with the procurements of carbon mitigation credits. So go to the next 2 slides, I guess. So the carbon mitigation credit procurement process, as I indicated, we published this plan on September 17th and then filed with the ICC on September 29th. And here's what we were navigating as statutory requirements and putting that plan together. So the procurement quantity, unlike with zero emission credits, where it's 20 million zero emission credits delivered annually, here we're talking about 54.5 million maximum amount of carbon mitigation credits delivered annually. So that's a big step up in terms of procurement volumes. It's more than 2.5 times as much as the amount of zero emission credits being procured. The applicant plants need to be in PJM by law. And then there's certain statements found in section 1-75D-10, where the carbon mitigation credit procurement piece is located in Illinois law, that exclude the LaSalle facility in particular. The contracts are for 5 years, but they begin June 1st, 2022. This is a little bit different than it was with zero emission credit procurement, where we conducted the procurement process across the fall and winter of 2017, but the delivery requirements actually predated back to the middle of 2017. Here, those delivery requirements don't actually take effect until the middle of next year. Only ComEd is the counterparty for carbon mitigation credits. What this means in practical terms as a ratepayer is that you'd see a surcharge potentially associated with carbon mitigation credits on your bill as a ComEd ratepayer, because ComEd is procuring those and Illinois ratepayers, ComEd ratepayers are funding them, but that's not the case for Ameren ratepayers with respect to carbon mitigation credits. The pricing on carbon mitigation credits is very different. We have an upcoming slide to explain that. It's more of a floating price. The zero emission credit price, again, can be adjusted based on market factors, but the carbon mitigation credit price has more of a floating aspect to it than just that. In terms of what that means for the actual price, for the zero emission credit price, you have that $16.50 plus the escalator and then the potential adjustment downward. Estimates for carbon mitigation credit prices are much lower, maybe $3 or $4 for a carbon mitigation credit. And frankly, if assumed energy revenues and possible capacity revenues go up enough, then you could actually have negatively priced carbon mitigation credits and Illinois ratepayers receiving a credit, or ComEd ratepayers receiving a credit associated with carbon mitigation credit procurement. The annual cost of this is not known in the same way it is under the Zero Emission Standard. Under the Zero Emission Standard, you had that $235 million ish overall rate impact amount. Here, we don't know the annual cost because of the floating nature of the price. The estimates that were being shared when this bill was being considered was $694 million total over 5 years. So you're talking about $140 million a year. So that's quite a bit lower than the Zero Emission Standards, $235 million, especially when you say, okay, that's for 20 million ZECs being delivered annually. Here, you're talking about $140 million annually for 54.5 million carbon mitigation credits. Again, it's not a capped amount. It can actually operate as a credit. So it's possible that if energy markets and energy prices go high enough, for instance, you could end up having a credit for the procurement of carbon mitigation credits. So as we go to the next slide. So what were the key issues in terms of putting together the carbon mitigation credit procurement plan and trying to distill down these statutory factors into something that we would then implement and use to achieve the objectives under law? Well, one of the big ones was, just as it was under the Zero Emission Standard, how do we select applicant facilities? It doesn't have to be just those facilities that are talked about during some of the public bill negotiations. Anybody could apply if they have a nuclear plant within PJM. And then how do we basically score competing applications in that case? The language in the carbon mitigation credit piece of the IPA Act borrows mostly from the Zero Emission Standard Plan in terms of the assessment of competing facilities. So we basically use the approach in the Zero Emission Standard Plan of having a public interest criteria reduced down to a scoring system and an economic stress multiplier based on the degree to which those facilities may be at risk of closure. And then adjusting that for the fact that MISO projects were not able to participate for carbon mitigation credit procurements in the same way they were for the Zero Emission Standard. And then with respect to the carbon mitigation credit price adjustments, the way that this works, and this will be talked about a little bit in upcoming slides, is that you have this maximum bid price in law, and then you subtract from that market energy prices and potentially available capacity revenues, and that leaves you with a differential which constitutes a carbon mitigation credit price. But where you pull information from and at what intervals is something that always has to be figured out in these situations. Additionally, there are provisions in the law about what happens if one of these facilities is excluded from potentially being able to receive capacity revenues due to the application of the minimum offer price rule. That's something we had to work out through the carbon mitigation credit procurement plan. And how do we then, under the way that the statute is written in the last 2 years, there may be some adjustment to the carbon mitigation credit price in that circumstance. And then what happens if there's federal subsidies? Right now, the Build Back Better Act, I guess it is, that's being debated federally, may provide support for nuclear plants. If that support is available, then ultimately what happens? And this was all litigated before the ICC and trying to figure out a process for how we adjust carbon mitigation credit prices to recognize potential additional financial support available to those nuclear plants. So as we go to the next slide. So the plan development, again, we wrote most of this over the summer of 2021. We kind of knew what the statutory text was likely to look like. We had no idea when negotiations were going to end or if there would even be a bill, but we wanted to be prepared in case there was. So we published that plan for comment on September 17th, got comments a week later, and then filed it with the ICC on September 29th. That was in docket number 21-0718. You can use the ICC's eDocket feature, see the different filings that were made in that proceeding, and see the commission's order in that proceeding. That order was released on November 10th, 2021. And then we tried to develop different instruments in coordination with that, because by law, this whole process was due to wrap up by December 3rd. And that meant that a lot of the different procurement forms and things that we put together, we were developing those while ultimately litigating the carbon mitigation credit plan approval. So as we go to the next slide. So I want to talk a little bit about the carbon mitigation credit price and how that's calculated, because it's very different than the zero emission credit price and certainly different than what we do with RECs generally, although probably the most similar thing is the index REC price structure that's going to be used going forward for utility scale renewables procurements. So you begin with the bid price, and the statute describes maximum bid prices for given delivery years. and then you subtract that available energy revenues and potentially available capacity revenues, and that leaves you with a carbon mitigation credit price. As a consequence, if energy revenues are particularly high or capacity revenues are particularly high in future years, you would have a bigger number on the right-hand side of that equation, and you would have then a capped out bid price, but you may have available energy revenues and available capacity revenues that exceed that bid price, and that's how you would end up with a potential credit for the carbon mitigation credit price. The statutory maximum bid prices are described in statute or are outlined in statute. Those are included below year by year. And then there are provisions that say basically, if there are monetized federal subsidies available to those facilities, then you would essentially include those in the equation as revenues. So if there's some sort of credit available to a nuclear plant where they're receiving another, say, $5 a megawatt hour for their production from the federal government, then that gets added in to the right-hand side of that equation and increases the likelihood that the bid price could potentially go negative, because we don't want ultimately both the federal government and state government, or more appropriately, federal taxpayers and state taxpayers, providing overlapping support to facilities to ensure that they're able to remain financially healthy. Additionally, as mentioned previously, if PJM were to apply its minimum offer price rule, and it sounds like this is becoming mostly moot, and as a consequence, supported facilities were not able to participate in those capacity auctions competitively, then there's the potential for also taking the capacity revenues out of the equation, because those would not have been available to those facilities. So that's the way the carbon mitigation credit price is set out in statute. We've gotten inquiries where parties ask us, like, what is the price or what is the cost? And the truth is that we simply don't know, because all of these factors that go into the cost outside of the maximum bid price are unknown at this stage. I guess some of the capacity revenues available going forward, we may know given the forward nature of PJM's capacity auctions, but we certainly don't know the energy revenues. We've seen a lot of volatility around energy prices in the last 6 months or so. So as we go to the next slide. So carbon mitigation credit procurement process and where we are now with all of this. Again, the commission issued its order on November 10th, approving our carbon mitigation credit procurement plan. The procurement event was held November 23rd. There was a commission meeting. This is the Illinois Commerce Commission approving the results of that procurement on December 1st. And then the contracts were executed by the parties, which is ComEd on the one hand, and then Exelon as the owner of the selected facilities on the other hand, December 3rd of 2021. So all of the whole procurement process itself is basically wrapped up at this point, insofar as we have the plan approved, we've conducted the procurement event, and the contracts are executed. But the big parts are what's next, and that's the actual delivery of carbon mitigation credits from these facilities and payments from those carbon mitigation credits, and that begins June 1st, 2021. And then there are monthly price calculations associated with what the price of carbon mitigation credits are as energy prices change and potentially available energy revenues change. And then we simply don't know what's happening federally with federal subsidies. So this is something that at the IPA we're trying to track pretty closely. It seems like PJM is moving away from a minimum offer price rule structure, or one that would potentially operate to the detriment of facilities receiving state administered support, but we don't know that yet. Sometimes there's a call and response, whether it's between state governments and the federal government, whether it's between state governments and the RTOs, that could leave us in a different place in a few years. So we simply don't know where that issue lies. So right now, for us at the IPA, we're trying to do our best to track what's happening federally, to see if there's any filing that might be required with the Illinois Commerce Commission to make an adjustment to federal subsidies. Barring that not happening, it's then just a matter of the mechanics of the contract taking over. That should be June 1st, 2022. That's a typo on my end, not June 1st, 2021. June 1st, 2022 is when the delivery of carbon mitigation credits would begin. If you'd like to learn more about this process and see some of the instruments that were developed, we've left a link into this presentation. This is for our procurement administrator's website that has the contract, it has some of the participation requirements, and then obviously the ICC's plan, or the ICC proceeding approving the carbon mitigation credit procurement plan. That's docket number 21-0718. So that's how, under the Climate and Equitable Jobs Act, support is provided for at-risk nuclear plants, and how that varies from what was done through the Future Energy Jobs Act and the Zero Emission Standard. And with that, we can move into any questions on all of this.
Thank you, Brian and Anthony, for sharing such valuable information. I am not seeing any questions come in into the chat window yet. We can give it maybe a minute or so to see if anyone has any questions.
Yeah, and that's perfectly understandable from our end. We understand that unlike some of the prior presentations about programs that we operate or procurements that we conduct, this isn't the sort of thing that a lot of parties can directly participate in. Not everybody has nuclear plants, it turns out. So it's understandable if there aren't nearly as many questions as we'd have on some of the other topics. Nevertheless, because this was such a big part of the bill negotiations and something that was talked about so often publicly, it is something that we wanted to provide a presentation on.
Actually, one question just came in. The question says, how do Illinois ZEC compare to New York?
I don't actually know the answer to that, and I apologize. We haven't really done the comparative analysis on our end at the IPA, mostly because we deal with the outcome of negotiations more so than we dictate the terms of what's put in the statute. So my guess is that a lot of these analyses were happening in parallel, for instance, during the formation of the Zero Emission Standard and what was happening in New York before NYSERDA. I know that the process for providing support for at-risk nuclear plants in New York was more administrative than it was legislative. So that's one difference between the two. Anthony, I'm not sure if you have any insights into this. I probably knew more when the litigation was going on and we had these two parallel cases, but that's been so long ago.
Yes, I was thinking the same thing. In 2018, I probably could have rattled off a very good response to that. But the significant difference in my mind always was the fact that the program in Illinois was developed through a legislative process rather than a regulatory process. But my memory is ultimately the reason why both cases were dismissed were along very similar lines. But the specific mechanisms for how credits were priced and delivered were quite different between the two states. That the slide Brian had that had the link to, why am I forgetting the name of the website that has summaries of different state policies, has very good summaries on it.
Yeah, the State Power Project website.
State Power, yes.
A really useful resource for anybody who's interested in these issues and wants to kind of dip into the jurisprudence around that tug of war between state governments and the federal government.
Great, thanks. So we don't have any questions, but since it is almost 1 o'clock and this is the last power hour of this year, I know IPA Director Anthony Starr wanted to share some closing thoughts.
Great, thank you. And I wanted to thank everybody for attending this final power hour of our 2021 webinar series. For the IPA, the launch of the IPA Power Hour really couldn't have come at a better time. We'd been thinking at the IPA about how we could expand our outreach and our education, our communications efforts. That was something that was evolving earlier this year. And then with CEJA being enacted, and it's such a complex and comprehensive bill, we realized that this was the time for things to come together and offer stakeholders and other interested parties a sort of series of educational, informative webinars where we could go through what CEJA revises and expands in terms of Illinois energy policy, and specifically those items that are managed by the IPA, such as the expansion of the Renewable Portfolio Standard, the new focus on equity, diversity, and labor standards in our programs and procurements, and then the topic today of the Carbon Mitigation Credit Procurement. So I want to thank everybody for participating and supporting the IPA Power Hours. We hope that they've been educational and informative. We've had hundreds of people listen to these this series of webinars, and by recording them and placing them on our website, one of our hopes also is that these become sort of an educational resource for people to come back and really look at sort of what are the core fundamentals of what CEJA is seeking to achieve. In the next week or so, we'll be sending out a post-webinar survey to all attendees. We're really interested in your comments and feedback on what we can do to improve these series going forward. And as we plan the Illinois Power Agency Power Hours for 2022, we'll use your feedback as we consider what topics to focus on for those future Power Hours. And then I also just wanted to wrap up by thanking the IPA staff who's participated in the Power Hours. We've used this also opportunity for some of the staff who maybe those external stakeholders have not had a chance to get to know, as an opportunity for them to present on a variety of topics around the work that the IPA is doing. And then I particularly want to thank our communications manager, Megha Hamal, and our chief legal counsel, Brian Granahan. This Power Hour idea was really their vision and their inspiration. And I'm really glad that we've moved forward in establishing the series. And again, I hope everyone has found these educational and informative. And with that, I'd like to wrap up, and I wish everybody a happy holiday.